Hello, good afternoon, and welcome to episode number 25 of At Your Service with Haber and Martinez. This is our post-Christmas, pre-New Year's Eve, what we call Betwixtmas show. Good to see you, Ed.
Good to see you, man. I like the Christmas hat.
Thank you. This is Miami Santa. Miami
I,
Santa.
I love when
Uh,
my Jewish friends get into the Christmas spirit.
I'm
It's
always
just
in the
about
Christmas spirit,
happiness.
year round.
It's all about happiness,
Although I do admit to a little betwixtness malaise, but that's only to
right?
be expected. Um,
It does.
maybe I have Omicron. Who knows?
I think I
Um,
actually have it. I don't know if I have it. I'm not feeling well today, but I mean,
well,
listen,
let's.
Mike. At this point, really, like, I think everybody's saturated with the whole virus thing. Like, it's like Judge Newman told me years ago when I was a young prosecutor. First DUI guy I got convicted three. He was a point three, man. This guy was
Hit,
hammered.
hit the eggnog a little hard, did he?
Oh, he was hammered. He was passed out in his car in the parking lot of the club. Passed out with the ignition, with the car running, but he was parked in the parking lot. Anyway, long story short, the guy was just a complete jerk. Didn't want to take a plea, any plea, no plea at all. Just completely just jerk. And I was a young prosecutor, so I was like, okay, well, the first offer is, whatever, DUI penalties. No. All right, the next offer at the next setting, a weekend. No. I just kept going up, right? He keeps saying no. He wants to keep going further and further in the litigation. Picking a jury, I think it was 10 days. After we picked a jury, I think it was up to 20. This is our first DUI. By the time we got a conviction at trial, I think I wanted like 30 or 60 days jail. So Ed Newman put him in there for a weekend. So after the trial and everything in the sentencing, I said, Judge, how can you give this guy a weekend? Don't you see that this guy is just arrogant? He doesn't care. He's disrespectful. I go through the litany of my examples, and he says, Ed, he's got no priors. Let me tell you what this is like. You ever hit yourself in the thumb with a hammer? First time you nail yourself by accident with a hammer, it hurts. Second time, it hurts a little bit. By the third, fourth, fifth, sixth time, eventually the thumb just gets numb and you don't feel anything. And so that's why he said, I only give him a weekend because he'll feel it. The weekend will hurt him. 30 days in jail, by the time the 30 days are up, he's not even going to feel it anymore. And
Well,
so
it's good to know that Newman was not punitive
he
and
wasn't.
treated him fairly.
I'm telling you, Mike, you know Ed Newman. He's a good guy. You
I
just
do.
don't
In
understand it.
fact, I can't wait for him to come join us on the show.
I know. I'd love it. His
Speak.
brain just thinks differently, but he cares about
Well,
doing the right
that's it's probably got something to do with all the concussions. Um, anyhow, let's get to our show for today, shall we?
Let's do it.
Which I have entitled CrimPro 102. What are these procedures that you speak of? We did a show on CrimPro. It was a flow-charted show talking about how the system kind of operates. But what I really want to do today is just hit the main bullet points of the criminal justice process, starting from very briefly when the police come into contact with the individual to the arrest, because the arrest is really what triggers the procedure, right?
Right.
So we're going to go from arrest to booking, to initial appearance and bond hearings, to what I call the Pre-File Nebula, to arraignment, not your arrangement, but your arraignment, to status conferences or calendar calls or report calendars, through discovery, depositions, motions, be them ordinary or dispositive, speedy
Correct.
trial, trial prep, plea bargains, trial, sentencing, and appeals. It sounds like a lot, but I think that in the next 55 minutes or less, you and I can blow through this relatively quickly, and give the folks some good pro tips in terms of what is it that your criminal defense lawyer, A, should be doing for you, B, can be doing for you, and C, will have done for you. And what might you have missed out on if you were not properly represented, either because A, you didn't hire a lawyer in time, B, you hired a hack instead of an actual attorney with a brain in their head and a care in their heart, or C, you simply have a public defender who I give nothing but respect to, but they're overworked, overburdened, and by definition do not have the time or the ability to give the personalized, custom-tailored, boutique-type treatment that you and I and other private lawyers hopefully give to our clients. So with that said, let's just jump right into an arrest. We've talked about seizures. We did a show on Fourth Amendments. Arrest is the ultimate seizure. That is where you are no longer free to leave. You are going to temporarily be a guest of the state. It's possible, based on the charges and the circumstances, that a police officer might cut you free in that moment and give you what's called a PTA or an NTA or a paper arrest. That is a promise to appear or a notice to appear. In some circumstances, the cops have discretion to do that. But otherwise, arrest triggers what most of us normally think of when we hear that word, which is getting cuffed, stuffed, perp walked, and then booked into the jail. So however it is that your arrest comes about, that is the first procedure that sets everything in motion, because from there, you're going to be taken to a jail, presumably. And if you are taken to a jail, then Florida criminal rules of procedure require within 24 hours, anybody who is booked into any jail anywhere in the state of Florida for any reason or for no reason to be taken in front of a judge. Why do we do that, Ed? Why do we insist on that 24-hour review?
Because you're right, because you're entitled to a bond in this state, at least, unlike some states up in New York where they're trying to get everybody out. You have a right to a bond, but the state also has a right to argue what that bond amount will be. In some cases, argue that they want to hold you no bond. So while you have the right to appear before a judge for your bond, the state has rights too. So that's really why you get that in the first 24 hours. You're in front of a judge to make a decision.
But before we even get to the issue of bond, the first thing that has to happen at initial appearance is the judge has to review the sworn affidavit or take testimony if there is no affidavit and make a determination that probable cause existed. Correct. Because the purpose of that initial, the first purpose of that initial appearance is for the court, for a neutral and detached magistrate who has no connection to law enforcement and no horse in this race, to be able to view the statement of probable cause and determine whether or not it actually meets the legal criterion for probable cause, right?
Right.
Because if there's no probable cause, if the judge decides that the cops jumped the shark, or they didn't have what they thought they had, or what they thought they had didn't amount to what they believed it did, then that judge is going to cut you free with no bond at all. They're just going to simply ROR you and walk you out of the courtroom. Right. Doesn't mean that you can't be charged later. But that's really the first fundamental starting point.
Because since you're on that mode, you're right. You said a very crucial term. You're not charged. Once you're arrested and you're taken to the jail and you're booked, you're still not charged. We put both. The charges come after a state attorney reviews that, which we're going to get into that in a little bit. This is just an arrest. And the judge is just making sure that the arrest was good. That's why, even though you think, well, a judge and lawyers, that's all beyond a reasonable doubt. No, this judge is reviewing what the cop did. She's not getting involved on whether it's beyond a reasonable doubt, whether there's enough evidence for any of that. She's just reviewing. Did the cop, was the cop complicit? And did they do essentially what they needed to do? And they only have to go as far as probable cause, which when I used to train at the academy, I used to give them the Reader's Digest version. What is probable cause? After you look at all the facts, is it more probable than not that a crime occurred? That's it. So it's kind of like a 5149 kind of an issue. I don't like using that because that's more of a civil term, but really that's what she does. And that's what the judge is doing. That's it. And you have the legal aspect where your lawyer can argue that it's not probable cause. You can make that argument to the court, and the state can make the argument to the court. Hey, no, judge, we think it did amount to probable cause. So all that is going to be your legal rights in the first appearance.
So let me jump on that and say a couple things. So most people who get booked and get arrested, taken to the jail and booked, most charges are bondable, and most people do not have some independent detainer or hold that precludes bond being posted. The vast majority of cases, if I get arrested at 9 o'clock at night, by the time I get booked into the jail and I'm entered into the system, if my bondsman is aware that I'm in the jail, bond can be posted, and I'll probably be released before that initial appearance in the morning.
True.
So, pro tip, always have a bondsman's phone number or your lawyer's phone number in your speed dial, or at least make sure that there's somebody that you can reach out to that can reach out to that bondsman. Because if bond is postable, then you can jump that gun and maybe be able to get out before that hearing ever even occurs. But there are some times where you just don't have a lawyer, or you're not able to make that phone call, or the police didn't give you the right to make a call. So let me back up, because I know we talked about this when we did CrimPro 101. When do you have a right to that phone call? Because you all hear it on TV every time, right? No, officer, I know my rights. I want my phone call. No, You're not entitled to a phone call until after you've been booked. You're not entitled to it. Now, that's not to say that most police officers are not going to allow you to make a phone call if you are not an asshole. If you're an asshole, they're never going to let you make that phone call, because they don't have to let you make that phone call. But they do have discretion. And so if you treat them properly, at least hopefully with respect and just, understanding that they're doing their job, and, you're caught in it. So no sense mixing it up and making it worse. But if you do, and you follow the protocol of doing things intelligently and smartly, the odds are the cops are going to let you make that phone call before they take you to the jail, so that your wife or your husband or your mother or your father or your son or your daughter, your best friend, your bondsman, your lawyer, or whoever, you can let someone know, and they can get on that process to hopefully speed it up, accelerate it, and save you from having to go in front of the judge. Because you never know what's going to happen in front of the judge. Like Ed said, first off, it's not just about you, it's also about the state. Because once we cross that threshold, if the judge makes the determination that probable cause exists, the next step, the next procedural mandate is a bond review. Are you then entitled to bond? And if so, in what amount? And it's not just a standard bond, because even though standard bonds exist in most places, judges have discretion. They can give you a higher bond, or they can give you a lower bond based on a series of criteria. And as long as they enunciate the basis for their decision, it's discretionary and it's not going to be overturned. So you have these two things in play. Now, if you're going to wind up in front of the judge, what's going to happen? Here in Dade County, you're not going to actually appear in front of the judge. You're going to appear by video. It's two-way video. You're going to be in the jail. You're going to be herded into an auditorium where they just call you by name. Whenever your name gets called in the calendar, you could be 2, 3, 4 hours of sitting there waiting.
Which, pro tip, this is another reason why you want to hire a lawyer at that stage, because if you have a lawyer at that stage, you get called out of turn.
I was just going to go there. So you're sitting there waiting to be called. If you don't have an attorney, you're in the normal flow. Plus, you're going to be behind every attorney who's on that bond hearing asking the judge to call their client out of turn. So you wind up waiting more and more and more. But if you have your lawyer there, you have two benefits. The first benefit is you'll be dealt with in a timely fashion. The second benefit is you will be represented by somebody who knows something about you. Even if you don't know the lawyer yourself, at least somebody has had the opportunity to speak with the lawyer, to explain to the lawyer who you are, where you live, how long have you lived here, what are your ties to the community, what is your criminal history, if you have any criminal history, what exceptional circumstances may apply to you. Are you a parent? Are you a primary caregiver? Are you a critical aid worker? Are you employed? Are you unemployed? Are you a property owner? All of these types of factors that affect a judge's decision-making process in regards to bond, your lawyer will know in advance if your lawyer is prepared and is there. But that only happens if you have an attorney. Otherwise, you wind up with a public defender. Again, I take nothing away from the PD. These guys and gals have a really tough job. They're there in the moment. By the way, same with the state attorney. State attorney shows up and the public defender shows up for bond hearings twice a day here in Dade County. We have a morning calendar and we have an afternoon calendar 7 days a week, 365 days a year and 366 in a leap year. There's no day off for bond hearings. So you have a prosecutor and a lawyer and a judge who are at every single morning and afternoon bond hearing calendar. And they know nothing about you or your case because they don't know you. They're just simply assigned to the courtroom.
As a matter of fact, if anything, it's usually in that scenario. Now, remember, let's make sure we're clear. The scenario where it's the state attorney and the public defender that's sitting in that courtroom. The person who knows the most about the defendant in that scenario is actually the state attorney.
Yep.
What does the state attorney know? Only what the cops have told them.
Plus, they got one more source of data too. State attorney they have the police report and they have your priors.
Right.
So if you have any prior history from anywhere, the state attorney is going to know it, and they'll be able to argue that as an aggravating factor in terms of bond.
And sometimes the cops will either show up or call the state attorney that's handling the bond and say, listen, it's not just what I wrote in that report. We've been following this guy, or we've been doing this, or we know that. So the state attorney in that scenario is the one that knows the most. That's why it's good if you can afford it and you have the time to hire somebody who's going to be able to have the time to know about you.
Right. So remember, that public defender is sitting there. They've got the same arrest affidavit that the prosecutor has. So they're able to look at the case, from a dispassionate fact and law point of view, but they know nothing about the defendant. Nothing. They've never met the family.
And all they know is what the cop wrote on the A form. Remember, it's what the cop is saying, because they haven't had a chance to talk to you. So they don't really know what is different. Or I don't want to say the cop lied, but even in a perfect world where the cop is being honest, he's still going to write it from his perspective and his point of view.
And so that's why, again, as a pro tip, if you can have a lawyer there, and you have to have a bond hearing initial appearance, if you can have your lawyer there, all the better. If you can't, you can't. It's just, again, the vast majority of these cases, people do not have their own private lawyers at bond hearings. The ones that do tend to fare much better than the ones that don't. It's, just really that plain and simple.
And if you don't have a lawyer, for God's sakes, don't talk.
Almost no judge is going to, they're not going to physically restrain you from talking, but virtually any judge at bond hearing is going to admonish you not to speak about the facts of the case, because you're on the record. And anything that you say, as we know, can and will be used against you. So let's jump to the next phase of the criminal process, right? You've got an arrest, you've got booking, you've got initial appearance. All of that has to occur and bond review, all of that has to occur within 24 hours. Subsequently, charges are either filed or not filed, and that occurs at a procedural hearing called an arraignment. The time frame for arraignments varies. It's supposed to be 21 days from the day of your arrest. It's not always 21 days. Sometimes it's a little more, sometimes it's a little less. Here in Dade County,
we lost you, Mike.
I think my earbuds just went out. Go ahead.
Got you. So at the pre-file here in Dade County, you typically have 21 days. The state attorney, now notice what I say, the state attorney has up to 21 days to file charges without asking for more time at all. So they have a full 21 days. They don't have to ask for extra time. If they go more than 21,
how's my volume check?
Yeah, drop them down a little bit. If they, for example, if the state attorney needs more than 21 days, they can get it from the court, but they need to ask for good cause. Now, good cause on the first, after 21 days, could very simply be the officer's out of town, he's on vacation, I need a civilian witness to take their testimony, sworn testimony, because that's what the state attorneys have to do. They have to take sworn testimonies in the pre-file stage from either the officers or the witnesses or whoever's the complainant. If they need time because they haven't been able to get a hold of the witness, let's say it's a civilian, the judges give you more time. Technically, under the law, after 21 days, the court could, if it finds that the state has not given them good cause, let you go ROR. Now, ROR doesn't mean just out of jail. You could be out on bond, but you still have the conditions of bond. If you get an ROR, even after you're out on, you've paid a bond, if you can get an ROR, it's helpful because you don't have to worry about the special conditions of the bond. But what happens there, particularly in Dade County, I have never seen anybody get an ROR on 21 days. After 21 days, the judge will give them, I believe the first one is what, 30 days and then 33, right? Then we go from 21 to 30.
And then 40.
And then 33 and then 40. Now, at 40, so every judge in that building gives you an ROR. Every judge.
So I want to backstep just a little bit if that's okay.
Sure.
This window here in Dade County, it varies. For felonies, it's almost always 21 days. The clerk just automatically sets it. The 21st day, 3 weeks from the day of your arrest, you're going to show up for an arraignment. Your case is going to show up for an arraignment in felony court. In misdemeanor and criminal traffic court, it's usually closer to 30 days before that arraignment is set. In any event, that is the time period, whether it's 3 weeks or 4 weeks or whatever it turns out being. This is what I call the pre-file nebula. It is an amorphous period of time where everybody is stagnant, the defendant is stagnant, unless you are trying to force yourself forward. Right. And again, this is another pro tip. This is an area where a private criminal defense attorney can involve themselves in the state attorney's decision-making process. When I was switching out over to my spare ear pieces, I heard Ed talking a little bit about the prosecutor's need to take sworn testimony. Well, that's the main purpose for this pre-file period. It's to give the state an opportunity to review the police officer's allegations. Remember, you've already had one check valve, presumably anyhow, if you didn't just post bond, in the form of a judge reviewing the police report for probable cause. But now the state attorney has to review it, and their review is a higher standard of responsibility. The state attorney needs to review it not only to see if probable cause existed, but to see whether or not a prosecution can ensue where there is a good faith basis with admissible, competent, substantial evidence to secure a conviction with proof beyond a reasonable doubt. That's the standard that the state is held to. So when they take this time period, what they are supposed to do is to review those reports, call in those witnesses, ask the questions that they need to ask, answer the issues that stand in front of them, kind of figure out their way around the case, and make a decision whether or not they're going to be able to sign off on this thing, put their name on it, and ethically turn it over for a judge or a jury to have a trial or some other resolution, right, where there is, again, substantial, competent, admissible evidence that shows proof beyond a reasonable doubt of the crime charged. The other purpose is, though, there's another purpose. Just because the cops arrest you for X doesn't mean that's what you're going to be charged with. And sometimes the cops get it wrong. Sometimes they fail to add charges that they should have added. Sometimes they add additional charges that they shouldn't have added. Sometimes they completely flub the case and charge you with something that you shouldn't have been charged with, whereas there was something else that you should have been. And these are the types of things the state attorney is looking at to try and figure out, okay, what is my case? Do I have a case? And if I do, what is it going to be? So how does this affect you? The defendant has no horse in this race, but if you have a private defense attorney and your private defense attorney is skilled and experienced, motivated, and prepared, we are going to involve ourselves in this pre-file nebula in an effort to convince the state to do X, Y, or Z, or to not do X, Y, or Z. We're going to come to them with proof.
Go ahead. I'm sorry, Michael. Finish it. Saying.
Go ahead.
Well, I was going to say, and as a pro
tip,
as a pro tip, we're really not here. Michael and I are not here as an infomercial or as a CLE. We're just here to give you the nuts and bolts, the real world of what's the reality that exists out there. And part of the problem is, this is why, like Michael said earlier, if you hire a hack, if they don't charge you enough, right? You go and you're just hiring a lawyer based on his fee. This explains why they don't charge, because it takes time. These are hours that need to be paid for. That, you know, the defense attorney has to prep. He has to do what he's got to do. He's got to look at sometimes even case law research. I know you've done it, right, Mike? We get a charge, you see the facts, and you start looking to see if there's any case out there on point to show that your client has a very viable defense that's attached to a case.
Well, here's right. So let's
even hold on. Even if you file this, dude, there's this case sitting out there that after you file it, I'm going to file a freaking motion and it's going to get dismissed. So why are we going to waste everybody's time? Let's do this now. You don't pay a lawyer enough money, he's not going to put in the time and effort.
And let me say why this is important. Anybody can get arrested. I mean, bad arrests, wrong arrests, unlawful arrests, factually inaccurate arrests. They happen all the time.
And it's not
but there's a big difference between having an arrest and having a charge formally levied against you by the prosecuting authority. So when it comes to things like background checks, having an information filed charging Michael Haber with A, Y, or Z is going to be very different than an arrest that was resulted in an arraignment that resulted in what's called a no action, meaning the state said, no, we're not going forward with this bad arrest. We don't like this arrest. We're not filing these charges.
You just mentioned it. There are, at every stage, let's say cases get dropped all the time, right? But at every stage, there is a different term. If you look it up on the website, on the clerk's website, or you go to the docket, it'll say something different. And Michael just mentioned it. If you get arrested, but the state attorney, chooses never to file charges, it will say that your case was no actions. So anybody who knows a cop arrested you and it was a bad arrest. If it's dropped for PC, it'll say dismissed, no PC. If the state files charges and then later has to dismiss it, that's called a null pros. So every stage, the reason that the case gets dismissed is labeled differently. And this is why it's also important, because anybody who's looking at it will know.
Language matters. Yeah, no, language matters. So look, again, this pre-file nebula, the reality is, and let's, get out of the theoretical and into the practical, okay? Every single felony case has to be pre-filed, all right? I have had now, only in 30 years of practice, I have only had one case that I know of where the state never pre-filed the victim, never spoke to the victim. The cops never even spoke to the victim. They got all of their information from third parties, and they never spoke to the victim, not once. Ultimately, we spoke to the victim as the defense. Our investigator found the victim, and the victim gave us wonderful testimony that said, no, it didn't happen that way. And I'm not prosecuting this case. But theoretically, in every felony case, that has to happen. It should happen in misdemeanor cases, but practicality, here at least in Dade County, where the volume is what it is, it just doesn't. There is no pre-file in county court criminal here in Dade County. It just doesn't happen. Domestic violence, county court, a little bit different. They take it a little more seriously, and they do try to pre-file. But in your DUIs, in your, solicitation of prostitutions, your shoplifting, your petty thefts, your basic misdemeanor cases, there is no pre-file. It just does not happen. The pre-file is a de facto review by the state attorney of the police report. And unless there is some serious question that stares them in the face, which forces them to go the extra mile to call in a witness and get clarification, they simply file right off the A form, and that's that. Again, this is another reason why a private. Wait, hang on one second. Okay. This is why a private defense attorney is so important, especially in misdemeanors. If you get a DUI here in Dade County, it's going to be that police report and the stack of DUI, the necessary documents that are required to be filed with a DUI arrest, that triggers filing by the state attorney. There's not going to be any discussion of the what or the why or the how of it. Whereas if you have a defense attorney, during this nebula, this pre-file nebula, we get to reach out to that county court prosecutor and say to them, listen, here's some things that you're not going to read in the police report. Here are some things that you need to know. And by the way, we're also able a lot of times to broker deals in a pre-file way that we could never have gotten outside and after the case is filed. For instance, sometimes you can get somebody into diversion where they're otherwise not diversion eligible because you were able to present the pre-filing prosecutor with facts sufficient to convince them to make the referral, where you would have never gotten that referral had you walked into the courtroom. Well, a great example in a DUI case is if you have an accident. You are per se ineligible for diversion here in Dade County if your DUI involves an accident. But sometimes you can have an accident that doesn't involve any other vehicle. Let's say you just rode up on a curbside or you drove into a utility pole or something like that. There are ways to try and maneuver these cases and get a variance and a waiver into diversion. But that requires a lot of persuasion and a lot of effort by somebody with skill and experience.
Correct.
Go ahead, Ed. I'm sorry, I didn't mean to.
No, it's quite all right. But you brought up another point that I wanted to make sure we're clear on. For the audience, for the practicality of it. Part of the problem is with the filing that some things get filed that should not be filed is So a lot of times it's not even a state attorney who's reviewing these. It's a paralegal. And I'm not saying that paralegals are dumb or they don't know what they're doing. That's not the problem. The problem is they've never tried one of these cases. Yeah, I always get it always works better when the pre-file attorney is an actual state attorney who actually was in trials, who tried some cases at the very least, because they can now see the bigger picture and they can see the pitfall. They can actually look at something and make the assessment, honestly and genuinely about whether they think it can be proven beyond a reasonable doubt. If you've never been in that position,
and the other thing
you
is,
don't really know what that means. You think, well, like a lot of these, they think, well, we've got it. No, what you have is probable cause. You do not have beyond a reasonable doubt. And since they've never been there, they don't really understand that. And no knock on anybody. What it is.
Every now and then, we will wind up butting heads with a pre-file attorney, whether it's a paralegal or a part-time ASA or a full-time pre-file ASA or specially assigned ASA. Sometimes, cases go into division or specialty divisions for pre-filing. So a lot of times we'll butt heads with them and get nowhere. But you know what? There's always a supervisor. There's always somebody else to go to. So these are things that you cannot do on your own as the accused. You have to have somebody doing it for you. Is the public defender going to do it for you? No. They're not even going to get started on your case until after arraignment, and we haven't even gotten there yet. What we're trying to do is to affect the course of the arraignment. But let's jump over to arraignment for a minute, because we've now gone from an arrest to a booking to an initial appearance to a bond review through the pre-file nebula, and now the state attorney has decided we reach arraignment, whatever the state attorney has decided. Arraignment serves three purposes. One, to advise the defendant of the charges that are going to be filed against them, whatever those charges may be. And if there are no charges, that's fine. They can be advised that the case is being no actioned and have a nice day. Two, for the defendant, if he is charged or she is charged, to enter a plea to those charges, guilty, not guilty, or no contest. And three, to make sure that the accused knows and is afforded that they have a right to counsel, whether it's private counsel because they can afford to hire private counsel, or the public defender because they are indigent. That is what an arraignment is. That is all that an arraignment is. It is a procedural pit stop. There's no fancy argument. There's no discussion about proof. There's no evidence that's laid out. The victim's not going to be there, or at least has no reason to be there. They could be there, but they don't have to be there. The cops don't have to be there. Hell, you don't even have to be there. If you have a lawyer, your lawyer can appear in your absence here in the state of Florida by rule. Another little procedural tool that we have in our footlocker. We're able to file written pleadings on behalf of our client, so that our client doesn't need to miss a day of work or a day at home or a day on the beach or their vacation or sleeping in or whatever the hell it is that they want to be doing while we're dealing with the state and the court in terms of their arraignment. So this is not an evidentiary hearing. It's simply a procedural hearing. And at that point, if charges are filed, whatever they are, you enter a not guilty plea and you request a trial, the case ultimately will be rolled over and two things will happen. Well, sometimes three. Many judges will, assuming that the defendant is not present at that arraignment, many judges will set it for a review within a week or 10 days, just to see if there's a way to get the case closed quickly. Judges want to close cases, period. They don't really care one way or another. And in fact, they shouldn't care. If they do care, if they have some horse in the race, they should be recused and disqualified, because their job is to be neutral and detached. The one thing that they should care about is, two things that they should care about are, number one, that you're afforded all of the due process that the Constitution says you're entitled to, but two, that they are able to manage, control, and keep to as low a number as humanly possible their own caseload. Because every single day, judges have an arraignment calendar. Maybe there's only 3 or 4 or 5 arraignments. Maybe there's 10 or 20 arraignments. Doesn't matter. Every day, new cases are coming in Monday through Friday. And if they don't get rid of a proportionate number of cases as to what's coming in, if not more, then they start to get buried under the weight of their audit. So Judges like defendants to appear at arraignment because once charges are filed, the first thing they say to the prosecutor is there a plea offer?
Right.
Because many cases are going to get resolved right then and there. And not unreasonably so, right? Many people know, look, they pull me over, they find, I have no driver's license, they lawfully arrest me for driving without a license, they pat me down, they do their search of my person before they take me to the jail, and they find a baggie of cocaine. All right, if the traffic stop was legitimate, my driver's license was legitimately suspended, and the cocaine was found on my person incident to arrest, I'm double dog dead factually and legally on that case. That's a case that's ripe to close at arraignment, right? If the state attorney offers me a withhold credit time served, meaning no probation, no conviction, many people are going to take that deal in that moment and walk out.
I was about to say I agree with you with a huge caveat, but you mentioned the caveat in your closing argument there, sir. It depends on my client. I always advise against, and I think you do the same, Michael. I've seen you. You advise against clients closing it at the arraignment. Now, notice what Michael said.
I'm not.
If the judge sets it 10 or 14 days out. At the arraignment, the reason Michael and I always advise our clients against it, unless my client says, listen, dude, it's just a suspended license.
I'm hell-bent.
Or
I'm hell-bent.
Battery, and I beat the shit out of that guy, and there's a video. I've seen the video. I'm going down. Okay. But generally we don't, because we like to see the discovery. That's why you're hiring us. You're hiring us.
And you never know. You never know what's going to happen in a week or a month or a year. I mean, a prime example, and you've talked about this more than once over the last several shows, but a prime example is Ed has 2 cases right now pending, both very serious criminal cases. But guess what? The arresting officer in both of those cases is now under investigation by the state attorney's office for committing a series of crimes. Now, had those cases been closed at arraignment, nobody would ever know that. It would have never come up, and you're not going to be able to reopen that case later, more than likely. And if you are going to reopen it, it's only because you're going to spend a fortune on an appellate lawyer and roll some serious dollars in terms of dice that maybe you can convince the DCA to reinstate the case.
And here's the problem. You may not have an appealable issue, because the fact that these officers are being investigated doesn't mean they committed a crime. Certainly doesn't mean it has anything to do with your case. But the problem, the real world issue, is they cannot testify now. They now cannot, depending on what the charges are, they can't testify. So the state can't go forward because the lead can't testify. So you end up winning the case really on a procedural issue. And I'm not saying that we're here to help people get away with stuff. But in both my cases, especially one of them, it is absolutely relevant, because the reason the officer is being investigated is exactly what our defense is, that this officer violates people's rights. So in that case, that one case, it really is relevant to my client, and my client's rights were violated when he was arrested. But even when it isn't, listen, it's just best to let's let the dust settle. Let's look at everything. So and then you have time to take a plea.
I think we're in agreement. Ed and I generally are not going to close cases at arraignment unless there's some absolutely moving, monumental reason for us to do so. But that doesn't mean it doesn't happen all the time.
All right. Wow.
When back in the pre-COVID days, when we used to go to court every morning and we were standing in the cattle call waiting for the arraignment calendar to conclude so that we could get on to our business, whatever it is that we had to do there are tons of cases that close plea out right there at arraignment. It happens all the time. I'll tell you where else it happens all the time: at arraignment on VOP cases, violations of probation. They plea out regularly. Why? Because they get offered a much better deal and they know they're going to get hammered if they go to a hearing. So that said, again, that's the point of the arraignment. Now, so some judges, if you're not there for arraignment, they will set the case within 7 or 10 days just for that purpose. We call it report re plea. They may have other terms for it in other places, but basically it's simply so that the judge can look at the state attorney and say, state, is there a plea offer? Defense, are you interested? And that gives the judge the ability to try and control their audit right up at the top, nipping this thing in the bud.
Right.
But if that doesn't happen, or if it does happen and it's rejected and the case goes, then there are 2 things that occur. Number one, the case is set for trial, whatever it is, a couple of months out. and it's set for status or report or calendar call 10 days or so, 2 weeks or so before the trial date. So what are the purposes of those two hearings? Well, obviously we know what trial is. Trial is trial. That is a disposition, a hearing, an evidentiary process whereby both sides present their evidence, challenge their evidence, and a judge or a jury makes a deliberation and a verdict. But before that trial happens, we have this status conference or pretrial conference or calendar call or whatever you want to call it. And that is a hearing that the court sets so that the judge can hear from both sides as to their readiness, as to the procedural posture. Is there anything outstanding to make sure that the case is actually ready? Because if both cases sound ready for trial, the judge needs to know how many cases do I have on my trial audit for that day? What's the ages of those cases? Who's in custody? Who's out of custody? There are all sorts of factors that the judge is going to consider when they get to their list of ranking from highest priority to lowest priority of the cases that are ready. But what they don't want to do is have your case ready for trial. You show up on the day of trial, and now they've got to litigate motions and have hearings that the court was never aware of because nobody mentioned it because it was never a status conference, or at the status conference, both sides kept their mouths shut. So the judge needs to understand what the deal with this case is. And is there anything that the court needs to do? Are there any rulings that the court needs to make? Are there going to be any pretrial motions? Many cases, for example, one of the things that I don't do in my cases as a general rule is I do not take depositions. We'll talk about that maybe in this show, maybe in a future show, but it's a strategic decision that I make as a defense lawyer. I would say 1 in 150, 200 cases, I'm going to take a deposition. In 149, 199 out of 150, 200 cases, I'm not going to take a deposition. But in every one of those cases, the judge is going to take my client, swear my client in, and ask my client, sir, ma'am, I understand that Mr. Haber hasn't taken any depositions in this case. Are you aware of that? Yes. Is that okay with you? Yes. And they need to do that because they don't want the case to wind up coming back on appeal because no depositions were taken, and the defendant turns around, gets convicted, and comes back to the appellate court and says, my lawyer was ineffective because he never took depos. So the judge nips that in the bud and protects the court by making sure that they inquire of the defendant, right? So these are the types of things that are going to happen at a status conference. Is the discovery complete? Were depositions taken? Are there any outstanding materials? Are you guys arguing about anything else? Are there things that you've stipulated to, agreed to? Are there going to be any pretrial motions that the court needs to deal with? We call them motions in limine. Things that the court can start to wrap its brain around to figure out how much time is this case going to take? How much effort is this case going to take? You know, we can look at the case and say, this is a 2-day trial, this is a 5-day trial, this is a 40-day trial. But really, the court has experience, or hopefully has experience, and is able to look at it, ask the appropriate questions of both sides, and then really come up with its own kind of take as to where does this case fall in terms of the court's resources and time.
Right. And
so during all of this,
as a practical note, again, for those that are watching, you're not familiar with the system, or even if you've been familiar with the system but you haven't seen it from a lawyer's perspective, lawyers like Michael and myself and several others out there that we all, Michael and I know who they are, who practice, who go to court, who go to trials, who actually do jury trials, and we really fight for our clients and do motions. After a while, you don't need to depose cops. They all say the same thing. We know exactly what they're going to say. 90% of them say exactly what's written in the report, even if they did not read the report. Before we take their depo, the first thing they do is they get their file, theirs and the arresting officer's file, and they look and they read to see what he wrote. And believe me, I mean, over my 20 years and how many thousands of cases, I'm sure you too, Michael, occasionally when you used to take depos, there's that one cop, 1 out of 1,000, that comes in and says, yeah, I read the report. That's not what happened. But think about it. 99% of the times, they're going to say, yeah, whatever it says in the report. So it's really not necessary to take it. Civilians, that's where I differ a little bit from Michael. I like to take civilian depos because civilians are not that sophisticated. And sometimes they make mistakes. Number two, most times civilians are a little bit more weary about lying under oath. So they tend to either not answer questions or say the right thing. But if you have a lawyer like Michael who says, hey, I don't need to take depots, don't panic. Don't panic. If he's been doing this long enough and he knows what he's doing, he doesn't need to take depots.
And the other thing is, if you're the client, ask. Don't be afraid to ask why. Right. Why aren't you taking the depots? Because I'm happy to explain to my client why I think it's better for me not to do it than it is to do it. What do I have to lose versus what do I have to gain? For civilians, here's the counter argument to what Ed said with civilians. They don't know who I am. They have no idea how I approach things, how I speak. They don't know my tone. They don't know anything about me. And they certainly don't know how I'm going to defend this case. They don't know where I'm going to attack or what I'm going to attack. Right. But in a depot, it's real easy for an attorney to tip their hat, even if they don't plan on tipping their hat. And most times when you do a civilian deposition, you're going to have a prosecutor there. And if the prosecutor is sitting there and they're paying attention and they're worth their weight in dog crap, they're going to pick up on it. Well, so, again, I don't really want to get into the pros and cons of depots, but let's talk a little bit about discovery and depots, because that's the next step in this process, right? As soon as the arraignment occurs, unless we had a lawyer who worked here in Dade County, very famous guy, Seizure, God rest his soul, never took a deposition in his life and never involved himself in the discovery process. He did not participate, which is, look, I am in the 0.001% when it comes to discovery. When it comes to depots, because virtually every defense attorney takes every depot they can here in Dade County or in state of Florida. It's just, it's the unwritten rule.
They most, respectfully, most of them do it incorrectly. You're absolutely correct. They tip their hand. And believe me, when I take a depot, that's exactly what I'm avoiding. I never let them know what I'm thinking. So
right.
Sometimes.
Well, the point where I was going with this is Seizure never invoked discovery.
Never.
He was the one lawyer who never, ever invoked discovery. And sometimes prosecutors are sloppy and they just simply send it out. And I remember seeing Cy go at it with several judges who said, well, you received a discovery, now you're bound. And he's like, no, judge, I didn't open it. I don't want it. I didn't ask for it. The state sent it to me. I've given it back. I don't want anything to do with this. And why would they do that? Well, if you invoke discovery, it's a two-edged sword. You're saying to the state, give me everything. But you're obligating yourself to also give the state everything. Correct. So you can't have your cake and eat it too. That said, we all invoke discovery in almost every case. It's almost malpractice not to. Now, that's not to say that you have to. Again, there are some cases where strategically I might not invoke discovery. In fact, in many a DUI case, I do not invoke discovery. Why? Because I know I'm going to get the documents that I need from DMV and through public records requests. Right. Why do I even want to have to tell the state anything that I know? But again, that's case specific, neither here nor there. So what is discovery? Discovery is the exchange of information between the government and the defense so that both sides can figure out what they're doing with their case. Right. Both sides can figure out what evidence they're going to try and challenge, what evidence they're going to try to admit, what witnesses they want to list, what witnesses they want to call, what documents or items they want to subpoena. This is all discovery. It is the acquiring and exchange of relevant information for a given case. And that starts 15 days after arraignment. If you make the discovery request at arraignment, the state has 15 days to comply, and it's what we call a continuing obligation. So if anything should happen to come up, for example, when Ed first got one of his cases where the officer's being investigated, the officer was not being investigated at the time. So discovery went on, the witness list went out, the police reports went out. But once the state attorney's office started an investigation into this officer, they then had to go to every single open case that this guy has that he's involved in and send what's called a Brady notice to all of those defense lawyers and say to them, just so you know, we have some information on this witness that we listed in your case. He's the subject of an ongoing, or she's the subject of an ongoing investigation. And that is part of this ongoing process where we get to reevaluate the case. So this discovery, depositions fall under discovery. It is a tool in the discovery arsenal for both the state and the defense. If the defense lists witnesses, then the prosecutor has every right to depose defense witnesses, just as the defense has every right to depose state's witnesses, with one exception: the defendant can never be deposed, right?
Right.
So shy of that, you've got discovery and depositions. Now, what does discovery and depositions lead to? It leads to motions. Motions are requests of the court to take some form of action. The most basic common is what we call a motion to compel. When the state sends out its, first of all, the state may not send out its discovery response. What do? Motion to compel. Judge, we want you to order the state to give us the discovery that they're obligated to give us. Or the state sends you discovery, but it's not complete. There's other stuff out there, or you believe that there's other stuff out there, or you know. For example, we get this all the time in DUI cases where fire rescue is called to the scene. They don't list the fire rescue personnel. They don't give you the alarm number. So you have no information. They may not even mention the fact that fire rescue was there. You hear it from your client. Now you've got to go talk to those fire rescue people because they ask questions, and the answers to those questions may be very telling and relevant to the case. Those people may become very important witnesses to either the defense or to the state. So these are the types of things, again, motion to compel. That's what we would call an ordinary motion, right? But then we have what's called dispositive motions. And so as this discovery process goes on, or sometimes even before the discovery process, like Ed said, there may be a case law that is so ironclad that based on the police report alone, you know this case is going to get kicked. Well, if you bring that to the state attorney pre-file and they agree with you, it's going to be a no action. If you bring it to the state attorney and they disagree with you and they file the case, you're going to file what's called a dispositive motion. It'll be an evidentiary hearing seeking to dismiss the case based on the case law. You may have a dispositive motion for stand your ground, for self-defense, for alibi, for entrapment. There are all sorts of different what we call affirmative defenses, all of which could result, or many of which could result, in a pretrial dispositive motion. But how do you get there? Usually through the discovery process, correct?
Correct. You got to do the discovery process. And some of these motions, again, let me give you a little real world pro tip why you want to hire a lawyer who knows what he's doing, has been around for a while, and has practiced these kinds of motions and practices, even at the pre-file stage or early on in the discovery phase. Let's say Michael files a motion and there's case law right on point that says that this case should not go forward. And either the prosecutor that filed it or the prosecutor who has it now in the division fights you back. Well, these judges, a lot of them have been around. They know Michael. They know me. They see Michael files this motion. They see that the state attorney should definitely have done it and didn't do it. Now it lands in the judge's lap because Michael has to file the motion. And the judge is like, yeah, Michael, I agree with you. Case dismissed. You know what happens the next time Michael's standing in front of that judge saying this prosecutor is filing something he shouldn't file? The judge is going to review it fairly. But there's always human factor. There's a little part of him that is thinking, shit, here we go again. This prosecutor is just a screw up. There's that human factor. And so, again, when you hire a hack, you don't get those benefits. That Michael, right? How many times have you and I walked into court and not filed a motion and just said, Judge, I don't want to do this, but if they're forcing me to file a motion to dismiss, I'm going to file it. And the judge will say, give me the A form. Right there in court. Give me the A form. I'm going to read it right now. Why? Because they trust Michael and I. They know that Michael and I are not going to file frivolous crap. So right then and there, they may read it. And then if they see that they agree with us, they might turn to the state. These are the practical, real-world reasons on why you want to hire a good lawyer. And good lawyers are going to be a little more expensive. That's just the way it is. Right or no?
Let me hit a few more. Yeah, of course. Let me hit a few more procedural points. Speedy trial. So everybody's got a right to a pre-COVID because we're still in COVID purgatory. But let's just talk generically pre-COVID. In every case here in the state of Florida, if you are arrested and you are booked into the jail, there is what we call natural speedy trial period. For misdemeanors, it's 90 days. For felonies, it's 175 days. And within that time period, the state attorney must take you to trial unless you have caused a delay or you cause a delay, which is very easy. You could take a continuance. You can not be ready for a trial call. You can fail to appear. Any of a number of things can happen very innocuously and sometimes even by accident. But assuming none of that happens, assuming that everything is flowing in the natural course, you've done nothing to compromise the flow of time, then it's a 90-day window or 175-day window, after which the state gets 15 days. It's called a window of recapture, where they have to take you to trial by the end of that time, or your case is discharged forever. That's called natural speedies, but there's also a thing called a written demand for speedy trial. And that is one of the very few weapons that defense attorneys have. It's like an atomic bomb that we can drop, because what it does is it locks the court, not the state, but the court, into a very limited window of time within which to take your case to trial, or the judge is responsible for a discharge, not the state attorney, but it's on the court. And no judge wants that to happen. And what happens when you drop one of these, we call them speedy bombs. When you drop one of these speedy bombs, you basically said to the judge, you need to take this case very seriously, irrespective of anything else that you may happen to have going on in your little world. And because of that, we have 2 judges here in Dade County who are what we call backup trial judges. And all they do is try cases. They don't have calendars. They don't hear motions. They don't deal with the day-to-day bullshit with attorneys. All they do is pick juries and try cases, and they do it specifically for overflow for judges who have their back up against the wall. They have too many cases set for trial. They have a speedy demand that they can't handle, whatever it may be. There's these 2 circuit court judges just sitting there waiting to pick a jury at any given moment. So the
dates are important, because the speedy trial, when we do the demand for speedy trial, there's a recapture window and there's this and that and the back and forth. But at the end of the day, generally speaking, you're going to be in trial within 60 days, 60 days or less, really. They're going to force the state, because what you're saying when you drop a speedy trial demand is, I am ready to go to trial right now, standing right here in front of you, Judge. You can bring a jury in. We're ready. Well, that forces the state to be ready.
In fact, that's the key in the standard. When you file that written demand for speedy trial, you're certifying as a lawyer. You are certifying basically under oath as a lawyer that you are ready to pick a jury immediately in that moment. And the judge has time, but theoretically they can say, all right, let's go. Get in here now. We're picking a jury today. We're picking a jury tomorrow. We're picking a jury on Monday.
And I'm going to share with you,
and one more thing. I'm sorry, just one more thing. Some judges will not let you out of a speedy demand.
I wouldn't.
They're not obligated to let you out of a speedy demand.
I would.
So it's not something that you're going to bluff. It's not a tool that you're going to use to bluff or play games. When we drop a speedy demand, we are saying to the judge, we're ready. Let's go. Or as one of my clients famously said to me, a line that I've used over the years, tell the judge, and actually no, he said, tell the prosecutor, come on with the come on.
Exactly. So, and here's why I want to get, so you can understand why when Michael says it's one of our most, I think it's really one of our most massive tools that we have as a lawyer. It helps in negotiation as well. And I usually don't like to give too much of my trial strategy, because I know people are watching, state attorneys are watching. I would never do anything unethical, neither would you, Michael. But there's a saying in Spanish, guerra avisada no mata soldado. When you let them know that there's a war coming, you're not going to kill any soldiers, right? But this is what I do like to share, because it's one of my pet peeves. I see so many lawyers, especially for some reason, public defenders. You're standing in front of the judge. The case was just filed. The case is not even 30 days old, meaning, remember the timeline Michael said on a felony, let's say, the natural speedies is basically, let's say for sake of argument, 175 days, 175, 180, depending on the recapture. You're only 30 days, 60 days into the speedy window. That state attorney still has, if it's 60 days, he still has another 120 days before he has to prosecute you. So why are you being an asshole? Why are you fighting with the prosecutor? Why don't just say like I do when they say, well, Your Honor, the state's not ready. Is Mr. Martinez willing to waive speedies? I would say, yeah, of course. Why? Because I know in the back of my mind, if they don't have shit, I could drop a speedy bomb tomorrow. So why am I going to pick that fight when maybe the prosecutor will appreciate that I played ball? Maybe they'll appreciate that I was very nice. Then I pull them aside and say, dude, what's the problem? Man, I can't get a hold of the victim. All right, how about this? As an example, dude, how about we set it for 30 days? And if you still can't get a hold of him, fucking dismiss the case. Fuck that guy. If he's not going to answer the call, obviously it doesn't mean shit to him. So what the fuck do you care? And now the prosecutor's like, okay, you know what? Ed and Mike aren't bad guys. We're making sense because I'm not saying anything that's not true. And they might drop it. But let's say he doesn't. Okay, fuck him. I drop a speedy bomb. We're being trial before the natural speedies are even up. So there's no reason not to. It's an enormous tool that we can use to either A, play nice and try and get more, more bees with honey, or if they piss us off, we're going to drop not a fucking vinegar bomb. We're going to drop a nuclear bomb on their ass because we now know when they're not going to be ready. God help them if we find out that their victim is going to, South America for Christmas. Guess what? We're going to screw up his Christmas vacation by dropping a speedy bomb. It's a tool that we use, and sometimes it's better to have a lawyer who understands that it's just as powerful a tool when we waive the speedy because we have this sitting there. So, or am I wrong, Michael? Because I see you laughing.
So Martinez is obviously very passionate about this, but a dispassionate way of saying it is it's case specific, and really it depends on the circumstances in the case. That said, we're pretty much at the hour mark. We didn't get to really hit up trial prep, plea bargains, trial sentencing, and appeals, but I think you guys get the idea that there's a lot of steps in the criminal process, and that was really the purpose of this show. There are steps that are in writing, that are procedural, that everybody are stuck with, but as you play this game, as you master this art, you start to learn ways that you can maneuver around the rules and manipulate the rules and use the rules to your advantage. And that's one of the things that comes with experience. So with that said, and an hour down, I want to thank everybody for paying attention. I want to apologize that we didn't get to complete CrimPro 102, but you know what? That means we could just do CrimPro 103 on another day. I want to wish everybody a very happy Betwixtmas, this kind of amorphous purgatory of a week between Christmas and New Year's, where hopefully you don't have to work too much and you don't have too much responsibility, and you can wear your Santa baseball cap and enjoy yourself. And it's absolutely gorgeous out. I mean, if you're living here in South Florida, you just have to be ecstatic, unless you're at work today in a suit, because it is truly something beautiful outside.
And please be careful.
Thank you all very much.
And be careful for New Year's. And I don't mean just DUIs. You go to a party, it's amateur night, everybody's out that doesn't normally go out drinking. People are in a bad mood. They might have spent too much money for Christmas or not had enough money to buy all the prep. Don't get into a fight. People are going to get stupid. Just avoid all these problems. You don't want to be the New Year arrestee sitting over at DGK on New Year's Day.
No, you don't want to learn criminal procedure over the course of the holidays. You definitely don't. It's at any time, but certainly not over the holidays. Anyhow, thank you all very much for watching today. We really appreciate it. We look forward to seeing you in 2022. Our first show, I guess, is what is it, the 4th or the 3rd? I don't know, whatever that Monday is.
The 3rd. Oh, I might be in court on the 3rd, so I may or may not be able to be. I may actually be in a trial.
All right, well, we'll see. We'll see. It'd be nice to start the new year. It'd be nice to start the new year strong. All right, folks. Thank you very much for tuning in. I appreciate your time. Ed, thank you as always. It's good to see you, my friend. And please give everyone my best, and we'll see you all next week when we're back at your service. Thanks again. Have a great day.